Good evening, everyone. I'm Ronald Presner, Chairman of the Zoning Board of Appeals for the Town of Mount Pleasant. Welcome to tonight's meeting. On the meeting tonight, we have 2 items on the agenda, and if we all behave ourselves, maybe we can all go home a little early tonight. Before we start, let me first introduce the members of my board. To my far right is Adrian Novak. Sitting to my immediate right is Mr. Nicholas DeCicco. To my left is Kathy Grabowski, the Zoning and Planning Secretary. And to her left is Mr. Herb Doerr. And at the far left is Mr. George Lapazos. And sitting at the table in front of me is Joseph Briganti, Building Inspector for the Town of Mount Pleasant. I'm going to not go through how we run the meeting, because the ones that we have here are pretty simple as far as the agenda is concerned. So I'd like to start off with 2529, Ben Rossman. Yep. Please come forward. Raise your right hand, please. Testimony you're about to give us the truth, the whole truth, and nothing but the truth, so help you God. Yes?
Yep.
Okay. You're the applicant for Spavia Day Spa. The premise is located at 988 Broadway in Thornwood, correct?
Correct.
And this parcel is designated on the tax map as 106.15-1-22. The application is for a special use permit for Town Code 218-63.1 for a massage establishment on a legal parcel of 12 acres in an M1 zone. Is this a renewal?
It's a renewal.
It's a renewal, okay. Have you done anything different than you've done when you got your first permit?
No. I mean, the last 6 years we've been operating and everything is exactly the same. So.
All right. No problems?
No problems at all.
Okay. I have no questions. Ms. Novak?
No questions.
Mrs. DeCicco?
Just ask the building department any issues or violations over the last few years with nothing on the way. Thank you.
Okay. Mr. Doerr?
No questions.
Ms. Lapazos?
Nothing, Mr. Chairman, thank you.
Okay. Do we want to make a decision on this application?
Mr. Chairman, I make a motion that Z2529 as submitted be accepted.
All right. Do I have a second?
Second.
Second by Mrs. DeCicco. Ms. Novak?
Aye.
Ms. Lapazos?
Aye.
Okay. Chairman votes aye. You're good.
Okay, thank you very much.
Yeah. Good luck on your permit.
See you in 3 years. Thank you.
Now we come to the main event. This is the appeal and application of Paul Rubio challenging a May 8th, 2025 determination by the building inspector which held that the property located at 434 Sherman Avenue in Hawthorne satisfies the doctrine of back-to-back splits as used previously in the town of Mount Pleasant. Is Mr. Rubio available? Mr. Rubio, would you come forward? Raise your right hand, sir. Testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay.
Okay. Thank you for the opportunity to speak this evening on this appeal. As I mentioned, my name is Paul Rubio, and I'm here with my brother Chris on behalf of my family to appeal the building inspector's May 8th determination that Lot 28 is a buildable lot as of right. Mr. Briganti bases his determination on the assertion that the subject lot, quote, the subject lot is a back-to-back split. Tonight, the question before you is not just about the one lot, but about how zoning law is applied in the town of Mount Pleasant. The so-called back-to-back split doctrine is not law. It's not found anywhere in Mount Pleasant zoning code and has no statutory authority. It's an idea that emerged in zoning cases from the 1980s, and even then the courts made clear that it doesn't confer any automatic rights. It's a tool that boards may consider, not a rule they must follow. In fact, New York courts have consistently reinforced that zoning determinations must be made on a case-by-case basis and always under the framework of the local zoning code. New York courts, including the Court of Appeals, have rejected the proposition that a property owner may bypass current zoning requirements by invoking a back-to-back split doctrine. In Kahn versus Zoning Board of Appeals of Irvington, 1996, the Court of Appeals ruled that landowner cannot rely on historic lot configurations or informal doctrines to bypass current zoning restrictions. There must be clear legislative entitlement in the zoning code itself. Harn Food LLC versus DeChance in Suffolk in 2016, Suffolk County, the court went further, stating that the viability of the back-to-back split concept is dubious at best, and that municipal discretion remains paramount. In his ruling, Justice Whalen expressly noted, and I quote, "Despite occasional mention of that common law doctrine of appellate division determinations, pronouncements from the Court of Appeals have cast serious doubt on the continued viability of such a doctrine," end quote. The owner of Lot 28 is not entitled to build as of right. The appropriate and legally required path is to seek a variance, as mandated under Kahn and Harn Food. As municipal officials, you're empowered to administer the zoning law in full accordance with the code and governing precedent. An as-of-right designation for Lot 28 is unsupportable and contrary to both established law and the clear intent of the town zoning code. As I've stated before this board in the past, it's my contention that lots 28 and 34 were in fact merged in 1958 when the zoning code was adopted. The building inspector's determination ignores the plain language of section 218-79A, which states, where the owner of a lot of a parcel smaller than is required by this chapter also owned or had under contract to purchase other lots or parcels contiguous thereto, such other lots or parcels shall be combined with the original lot, whereupon a zoning permit may be issued, but only for such combined lots or parcels. That's exactly what happened here. In 1958, lots 28 and 34 were under common ownership and were contiguous. The code does not limit merger to side-by-side. Rear adjacency qualifies under the statutory language. Thus, the lots were merged by operation of law and have remained merged. The retroactive application of a post-1980s legal theory cannot override statutory law in effect since 1958. The merger happened automatically by operation of law. There's no provision in the code allowing those lots to be unmerged, and certainly no provision that allows an informal doctrine like back-to-back split to override the binding local statute. In fact, to treat lot 28 as a buildable lot today would require this board to ignore both the letter and the zoning code and the intent behind it. One would think that when they adopted R10, they were looking to deal with density and chart a path forward and included a fair remedy for those people at the time who owned properties and were seeking to use their properties. So I do believe that that was the case. In fact, for these reasons, I respectfully urge that the board apply the correct legal standard and require any proposed development at Lot 28 to proceed through a variance process subject to full review and public input. I'd like to ask my brother to address the question from the building inspector's letter regarding back-to-back split, particularly the third provision, which Mr. Vitigliano raised in his original letter in March of 2025 when he came before this board. So, Chris?
I have one question to ask you.
Sure.
On that back lot on Warren Avenue, it's less than 50 feet wide, is it not?
I believe so.
Looking at a map
The
here,
way that it's...
comes out to about 45 feet.
In
frontage.
terms of the way it's shaped, yes. It would, yes, I would, again, without going through details about what would be required for a proposal for a structure on that property, yeah, it has occurred to me that there's not a whole lot of room there. I know there was a proposal to subdivide the property in the 70s and to build a house on that lot. I don't recall exactly what they were requesting in terms of clearances and things. I don't know. But it's a narrow, on Warren, it's quite narrow there.
Right.
It's angled. And I guess the code establishes that it's the line, the actual line, whether it's an angle or not, how many feet that line is. So I think it's under 50 feet.
It's under 50 feet.
Yeah.
When these lots, correct me if I'm wrong, when these lots was established, these were more for like summer homes?
That's been presented, I know it was presented by Mr. Vitigliano, quite possibly, yeah.
So as summer homes, somebody could buy one lot, 50 by 100, 2 lots, 4 lots, correct? If they wanted to?
They could, yeah.
Yeah. So over the years, the front lot on Sherman Avenue and the back lot that faces Warren has been used, part of it, because you got that steep slope there. But that had been used by the family that owned the Sherman Avenue property, correct?
Correct, and my brother will talk about that in more detail.
Is that the same thing true to the person to the left?
Person to the left,
You know, if I'm facing the house, it's to the left.
on which street, Sherman or
I'm
Warren?
on Sherman Avenue, I'm facing the house, property to the left. Does that have the same situation?
Does it have the same situation? That would be my mother's property, our
Okay.
property that you're
Yeah.
referring to. Have we been using the,
Now, is that considered one lot or 2 lots?
well, it's got one deed. There's one deed. There's 2 tax parcels. The front parcel and the back parcel. So when my mother pays her taxes, she pays for 2 tax
So if
parcels.
it's, then there should be 2 deeds, correct?
I'm not sure why there are not 2 deeds. We don't know why there's only one deed, and perhaps the owner's cognizant of the zoning law
It would be
saw it
like
as
me
one
paying
property.
my taxes, and then my neighbor next door, I can pay his taxes too. That's what it, you know, basically would come down to, in that case.
Mm-hmm.
I'm sorry, I didn't hear what you said about taxes.
The taxes are being paid on the property that Mr. Russo's mother owns. There's 2 tax lots. I can't have anybody raising their hand. I
That's
gotta
okay.
have one
Go
conversation.
ahead,
going.
I'll, yeah, that's all right.
Please.
Yeah, yep.
So you have that one property and there's 2 tax lots, correct?
Right, it's under one
All
deed.
right. And it's all under one deed.
She purchased it that way when she bought the house in 1978, yeah.
And this property on Sherman that we're discussing has the same situation, except it's 2 deeds.
That is a fact, yes.
Okay. Your brother said he wanted to speak?
Yeah, unless anyone else has questions for me, and certainly afterwards, if
not
you have
at
more
this
questions,
point.
I'd be happy to ask. But I've
Well,
asked,
well, let me go back.
sure.
Let me ask the members. Ms. Novak, you have any questions?
Not at this time, but I would like to reserve the ability to ask some afterward. Excuse me, I apologize. I just had some dental work
Sure.
done, so I am trying to work through it.
Okay.
I would like to hear from Mr. Vitagliano as well, and I may have further questions afterward.
Mr. DeChico?
Same, Mr. Chairman.
Mr. Dorr?
Same.
Mr. Lepatos?
Just one question, just to make sure that I understand. When you had discussed the ownership of the property by the original owner prior to the code in '58, the 2 lots that are at issue here were separate building lots, is that right?
They were owned by the same person.
It's not really my question, though. They were separate building lots at that time?
I actually,
Separate tax lots?
Tax parcels.
separate tax parcels. And you say building lots, but that would be by definition of the zoning code and the enactment of the 58 zoning code and what was supposed to happen at that point. So when you say building lot, I would say that that's a complicated answer to that question, or very straightforward. If it was 1958, they would have become one building lot.
Yeah, my question was prior to '58, if those 2 lots were separate lots, separate tax lots.
Yeah, and under cases that have happened before this one, if something was not owned by someone owned the front lot, they didn't own the back lot, and that's a different situation. They're not owned in common. They don't become merged at
I'm
the
just
point
trying
of
to-
the zoning code
I'm
being
just trying to
adopted.
recognize
Okay.
What you,
Well, you asked the question about being a building lot.
I did use that word.
Right,
And I
so-
used that word because prior to 1958, both of those lots could have been built upon independently. But the proper way I should have framed it was to use tax lot. So I'm just
Correct.
clarifying that at the time that the original owner, prior to 58, I don't know if it's the original.
Yeah, that's
But-
correct. They're both tax lots. They're established as tax lots. My mother's property is the same way with 2 tax lots. So,
I have nothing further. Thank
okay,
you.
thank you. Chris, you want to talk about that? So Chris, well, I'll let him introduce
Oh, I
himself.
guess I'll introduce myself. I speak a little louder than my,
Raise your
than
right
my
hand.
brother, I'm sorry.
All right, testimony about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
And give
yes.
me your name and address.
My name is Chris Rubio. I live at 7406 Willoughby Avenue, Los Angeles, California, 90046.
Congratulations, nice quiet town.
Well, you know, it's a little wacky these days, but I've been here for the past month. Unfortunately, I missed the last meeting.
Okay,
Can I start?
go right ahead.
All right, I'm gonna have to talk over here.
All right.
Just as a little, like, refresher, because I'm
You
not
can
sure.
take the mic with you.
Oh, I'll do it this way.
I think his voice is.
Okay. Yeah, well, you know, Los Angeles, it's the law. Just as a little refresher, this is Lot 28, and this is the orientation of Lot 28 and Lot 34 right in front of it, okay? This is my mother's property, and her Lot 27 behind it. In September of 2024, the gentleman who currently owns Lot 28 is a contractor who purchased the front property, which he did a beautiful job of remodeling and has resold, and has sought this determination for Lot 28. Okay? Just to give you the orientation of the 2 lots. I have some other show and tell items that I'll get to in a minute. I'm going to make this as quick as possible. This photograph is taken from exactly this spot, looking from the backyard of Lot 34 onto this rear portion of Lot 28. That is a photo taken recently. Okay, so in fact, just 2 days ago, the new owners of the property had their grass cut, and they went on to the back, which is actually somebody else's property now, and cut that lawn. I believe it was Mr. Vitagliano in his first statement who said that there was no utility or value added by this lot behind Lot 34. Due to the topography, he said, there is no added value of utility or value to Lot 34. And I think it's pretty clear that the only usable backyard to the property, about 2,300 square feet of Lot 28, which is flat, I would like to argue that it does add to the value and utility of the lot. This is, of course, the overhead photo, which showing the picnic tables, the fire pit, the shed, and other items in the backyard. I did explain that I lived at 438 Sherman Avenue since 1978 for 25 years. My mother lives there now. And I can obviously personally attest to the constant usage of that backyard as a, backyard to the property. A lot has been said about this concept of back-to-back split. I didn't know anything about it a few months ago. But thankfully, Mr. Vitagliano, at the previous meeting, discussed the so-called doctrine, which, to be honest, to me seems more like an exception, but okay, let's call it a doctrine. He said that in the meeting, quote, and I quote him, "The concept of back-to-back split is something that emerged in the courts from the cases in the late 1980s, and there are certain requirements for them." Okay. And going on, quoting him, the frontage would be on separate streets, which obviously they are in this case. 2, they must meet the depth characteristics, which they do. And the third, and most importantly, they must never have been used in conjunction with each other. never have been used in conjunction with each other. Want to just point out these photos. This one was taken in fall of 2024 when this back property, along with the front, was purchased. The fire pit, the shed, the 2 picnic tables, and there's some firewood stacked around. I know because I helped the guy move it and put it out front. This is a shot of the rear lot from the Zillow ad, taken at the same time. No value or utility. Yes.
Can I just stop you for a
Yeah.
moment? So I'm clear.
Yes.
The picture on the top, the house we see on the right is the back of 434 Sherman Avenue.
This is the garage of the 434.
434 Sherman Avenue. But let me make sure I got this.
Yes.
So that's 434 Sherman Avenue, the garage. But where we see the fire pit and the table and what is that? A canopy of some sort? Right there.
This is a shed.
So the shed, that is actually on the back end of lot 28.
Correct. That is on the about 2,300 square feet. I could show you up close here. 2,300 square feet of the rear of lot 28.
Okay, I see
Okay.
where you have it designated.
Yeah.
Okay.
I think.
And how long was it, the picture we see on the top over there, approximately
Yeah.
how long was it utilized in that fashion as far as you remember?
They used it, and I'm going to provide more evidence.
Okay.
I lived there since 1978, and it was always their backyard, and they always used it as their backyard. In fact, this piece of property, lot 28, well, this is actually the flat third of lot 28,
Right.
was for sale on Zillow for $199,000. Didn't sell for $199,000. According to Zillow, it sold for $121,000. And I believe that is because it wasn't a buildable lot, and the contractor who purchased the front and the rear was taking a chance that he might be able to build on the lot. As he said, he actually said to my mother at the time, I want to build a house back there. And I actually called him to find out when he was going to start building a house, because I was concerned, my mother wanted to know. And he said probably not for some time or something like that. And actually this process has been great because I didn't even realize that we would have some kind of recourse or anything to say about the building of the house. But apparently there are laws. Again, I'll go through this quickly. The third stipulation is that they must never have been used in conjunction with each other. And I want to point out why I believe that stipulation is there. It's because it protects the town and the people of the town from after-the-fact efforts to separate what has long been treated as a unified residential lot. In fact, it's been owned in common since about 1952. I looked at all the deeds. It's been owned in common up until September 2024. To separate what has been treated as a unified residential lot simply because it's become financially advantageous to do so. Again, this is not a long-standing person who had a lot back there and never used it and said, hey, you know, I know it's not enough space, but I'd like to build on there. Could I please build on there? This is a contractor who purchased the front, did a beautiful job, and now wants to build on the back. And I might add, as according to Mr. Vitagliano, went for a determination from the building inspector, who then punted to the town attorney, who then gave it to you folks, who quite rightly said, well, we're not here we're the zoning board of appeals. We need an appeal to speak. So it went back to the building inspector, who then made a determination. So it wasn't a cut and dried, apparently, right away. So, speaking of Mr. Briganti, the inspector, he concluded that the historic use of Lot 28 was de minimis. In other words, too small to be even considered. And I would like to reiterate my evidence, having lived there since 1978, of what that backyard was used for. The lower third of Lot 28 was at various times contained a 10 by 10 shed, which I showed you, a fire pit, picnic tables, a trellis, stacked firewood, seasonal seating, a screened-in enclosure, and even an inflatable children's pool. There was never a fence. There is still not a fence there. Never a boundary or any indication that the land was in any way separate. It flowed directly from 434. It goes up 2 feet towards those rocks in the back. You walk right on the land to the back. Again, I didn't make up the determination that these two pieces of land must never have been used in common with each other. That's the words of the attorney who knows the law.
There's also a set of steps to the left of the garage that go from the garage up to the backyard. So it's,
Yeah.
to the left of the garage.
Yeah, my brother's correct. In fact, I think the attorney Vitagliano mentioned something about the garage was once, they got a permit to move the garage, or I'm sorry, to rebuild the garage. And he said, well, he tried to make the argument that they didn't put it to the back of the property because they wanted to maintain that as a separate building lot. In reality, to put the garage from here back here would put it right in the middle of the only yard that they used. This would be a 100-foot driveway instead of a 75-foot driveway now. I would argue that the reason they didn't move this was not because they wanted to maintain it as a separate building lot, but because it was their backyard. Continuing, you had the letter from my mother, sent it to the town. I know we hit you with a lot of documents. Feel pretty passionate about that. She's lived at Sherman Avenue for 47 years. She gave you a letter where she said, quote, the rear portion of Lot 28, specifically the flat lower 1/3, has always been used as the backyard of 434 Sherman Avenue, end quote. Continuing, on the April 10th, 2025 ZBA meeting, you also heard objections from Ms. Tammy Stephen, who is here tonight, and also from Kevin Hopkins, who is not here tonight but lives at 405 Warren Avenue, directly behind and beside Lot 28. And he said, quote, it, meaning Lot 28, was used as a yard. I live next door to it. I'm actually looking down on it. They always were out in the yard, entertaining, hanging out, so that's true, end quote. That's the person who lived next to it. And despite all of that, the esteemed building inspector found the use to be de minimis. If that's de minimis, I'd like to know what de maximis is. As I said before, Attorney Vitagliano said, due to the topography of the lots, it is impractical for the subject parcel, Lot 28, to contribute to the value or utility of 434 Sherman Avenue, end quote. He also said, quote, we maintain that there was no interaction between the two lots. And that really gets to the crux of why I'm so passionate about this. It's not because we want to do the same thing and sell our property and make money. It's because this is fundamentally untrue. And we don't care, to be very honest with all of you, that, if he gets his, then we could sell ours. We like ours the way it is. We don't want to sell ours. We know it's worth a lot of money, but so is the value to our mother who's lived there for 47 years. That's to be quite truthful with you, that is our motivation.
So,
Yes.
to be clear, so your family home is 438 Sherman, right?
Yes.
And your mom or your family also owns the lot 27 as
Yeah,
well.
the two tax parcels under one deed, yes.
But your argument is essentially that they remain two separate and distinct tax parcels, and in theory, even though you don't want to, you feel that in the future, if you choose to do so, lot 27 could be sold as a separate and distinct buildable lot, because at no time have you used it.
No, not at all.
No?
No, we're not interested in selling lot.
I know, but your argument is that
My argument is that his lots are merged.
Right, and yours are not, because you haven't used it in the manner that you claim that 434 has used lot 28.
No.
Is that true?
No, that is not what I'm arguing at all. We don't have accoutrements and things in our backyard, but yes, we've used it. It's my mother's backyard. We cut the backyard. I'm not claiming, it's funny, everyone has said to us, including the the real estate agent, you know, you could sell that. If he wins, you could sell yours too. We don't want to sell ours. We're not saying it's separate. We're saying it's merged, just as this gentleman's is.
Let me ask you this one
Yes.
quick question. You say you have two tax bills on the one,
Yes.
and it's one lot.
It's two tax
taxes
parcels
and
under one deed.
One deed. So theoretically, that's one lot, correct?
I don't know the
I don't
law.
know
I know
either.
she gets two tax bills, it's two tax parcels, and it's under one deed, most certainly.
Because it gets kind of confusing. The property that we're talking about are two separate deeds
Two separate
and
deeds.
two separate taxes. The other question I have is, you mentioned before that the present owner or the new owner of the property on Sherman
Yes.
went out and mowed the back lawn.
Well, yes,
Right now.
yes.
Does that person think that's his?
You'd
It's a
have to,
question.
I will say
It's a
this.
question. It's a question.
I will say this, the Zillow ad for 434 Sherman Avenue has and continues to list Lot 28 and the size of Lot 28 on the Zillow ad for 434 Sherman Avenue. We haven't brought that up since it's not for us to decide what happens. But it has the listing as 6,970 square feet of this lot, and also lists the tax parcel as 28, not 34, which is what it is. I hope the folks who bought this house know that this is not theirs. I have no knowledge otherwise. I know the real estate agent had the backyard cut last week, and oddly, she stopped along this line, leaving this little part of that little backyard. I don't know if she knows where the property lines are, but the person who just moved in went right over it and cut the back lawn as well. I don't know what they know that they've purchased or not.
You know, if you take the word assume and you break it up,
Yes,
you know exactly what it does.
that's why I'm not making any assumptions in
Okay.
that regard.
So it would be incumbent upon the property owner in the front to have, or whoever bought it, to have that actually designate where the property line is.
Well, there are a couple of orange marks from a survey that was
Survey?
done, but it's so obvious that you go from this line, this from here to here, that I'm sure the assumption of anyone cutting the lawn is thinking, well, of course I'm cutting this, it's part of the same property. I don't know what the new homeowner knows or doesn't know. I know the Zillow ad was wrong, but that may just
Right.
be the Zillow ad. So I'll finish up. It's interesting that you mentioned a number of times that there were two separate deeds. No one has said anything in terms of the determination. The determination is it's a back-to-back split. The determination is not, because it's two deeds, go ahead and build there. Determination is it's a back-to-back split. The three criteria were laid out by Mr. Vitagliano. The third criteria is must never have been used in conjunction with each
I
other.
understand that.
Okay, so just want to, in fairness, it appears that the current owner of Lot 28 purchased in September 2024 what was and continues to be a non-buildable lot with the intention of pursuing this determination. He's not an ordinary homeowner who requires relief to build on a second unused lot. He's a contractor needing an as-of-right determination in order to build on Lot 28. Without it, he would have to apply for a variance, and of course, in that case, any hardship he claims would be self-inflicted. That's why he's needed an as-of-right determination. It's probably why he didn't get it right away, because it's like, well, this is a little questionable. To reiterate, we are not trying to maintain that our two lots are separate. They are merged by operation of law. We are not looking to separate them or sell them separately. We like it the way it is. Hopefully someday our descendants will be living in it and keeping it the way it is. So we're not trying to pull a fast one with you. We're trying to follow the law here and maintain it the way it's been, under the law and because it's what we would wish to happen. So I respectfully encourage your board to reject the notion that the evidence and testimony presented here qualifies as de minimis use of Lot 28 and urge you to overturn Inspector Briganti's determination granting Lot 28 buildable as of right. Thank you for your indulging of my histrionics, and if you have any questions, I am happy to answer them.
Not at this time. I think we would like Mr. Vitigliano to wishes to address the board. You're excused.
Thank you.
Thank you.
Good evening, members of the board. Aldo Italiano, 150 Purchase Street, Rye, New York. Here for Soldy Lane Associates.
I don't think the mic is working.
Check 1, 2.
I guess the mic ran out of gas.
If you guys need one, take another one.
Okay. Good evening again. So, I am here with my client, Soldy Lane Associates, Principal Stephen Suresh, who's the owner of the property on Warren Avenue. I'm here to urge you to support the decision of your building inspector, Joseph Briganti. We've handed up a copy. You had a copy already. And that was, for the record, rendered after hearing testimony and evidence provided in Zoning Board Application Z24-7. I've asked that the minutes of that meeting, which I have only one copy, be added as a part of this record, as well as the record from Z24-7, since they kind of relate to the same sort of thing. For the purpose of this application, I've submitted the minutes for it, only one copy for it. As a start, while a decision of a building inspector is not infallible, it is entitled to great deference. I would point out that he states that the subject lot would not have merged. I point out that the Town of Mount Pleasant Code has never had a merger provision. The building inspector goes on to opine that the parcel is a legal non-conforming lot based upon the doctrine of a back-to-back split. I want to make clear some facts, and for that purpose, we've handed up surveys of the two parcels, the subject parcel and the parcel at 434 Sherman Avenue. Like it or not, the rear property line is angled, if not L-shaped, and that is a factor that relates to a determination in Blue Ridge Gardens versus Oswald, a copy of the decision we set up. The rear property line abuts at 434 Sherman for 42.22 feet, but in fact has a total rear property line of 117.12 feet. It's quite obvious that the original intent of the subdivider was that these were to be separate lots. We've handed up the old maps. These were again in the old, in the last hearing. Exhibits A and B on the submission letter dated April 30th. Clearly, the Warren Avenue lot was intended to be a separate lot. The farmhouse, which was created on Sherman, was constructed in or around 1920, well before Mount Pleasant zoning code. Back-to-back splits have been recognized by the courts. See the matter of Moran versus CBA Irvington, and more importantly, by your zoning board. We've given decisions, okay? We point out the case of Heller, which concluded that a back-to-back split is a matter of right. In that case, one board member didn't believe that the board had to decide on the application. We also point out the case of McVeigh, again, a back-to-back split as a matter of right. There's also the Cervello case, where the board did not need to reach the determination of whether a back-to-back split applied, and for the record, in that instance, de minimis encroachments of sheds or other structures did not prevent the grant of that approval. Mr. Chairman, you were a member of that board, Cervello. Courts have long held that a review of an administrative or board decision is covered by a guiding principle that if the decision was reasonable, it should be given deference and not overruled. Courts in Article 78 cases adhere to this standard of review. It's only when a zoning board determination is arbitrary and capricious or against the weight of the evidence that they'll overrule a zoning board. We believe that your board should give similar deference to the building inspector's decision in interpreting the zoning code, which clearly is a reasonable one, made after a review of facts presented to your board in a prior application. This wasn't something he woke up and thought about. He had the opportunity to hear all the evidence, most of which is the same evidence that you're hearing tonight. So we believe, okay, that his decision is not arbitrary and capricious, nor is it against the weight of the evidence, and we urge your board to support your building inspector and sustain his determination.
I have a question to ask you. On front yards, if they were to build a house on that lot, you'd have to have a 30-foot front yard setback, correct?
I believe so, yes.
Okay.
And they likely have to come before you for variance.
The question is, there's a steep slope right there.
That's correct.
How far from the street is that steep slope, roughly?
I believe it shows on the survey. I think it has the rock outcropping on the survey.
I'm just looking at the main
Yeah.
one between the back-to-back split. The reason for I'm saying that is that that's a pretty steep.
As is
slope.
many
As
of the
it is
lots
now.
in,
It's very steep.
along that strip.
Right. And the basic opening of that property, if you go back, all right, you have at least where the house would, forget that there's a drop-off. Going back 30 feet, then you would have 50 feet of side
Correct.
front yard setback. But your depth right now is going to be a big issue for you.
Perhaps.
All right, it's going to be a big issue for the homeowner on Sherman Avenue too, because he's going to be looking up at a cement wall. Unless somebody's going to put a lot of dirt up there and re-slope that area.
There are numerous lots that have been
God
developed.
does things in
Okay.
strange ways. Because I'm looking
And for the
at
record,
this-
the closing took place today, so.
Excuse me?
The closing took place today on 434, so it wasn't the new homeowner that was cutting the grass.
Yeah, but I'm looking at it from 2 points of view. I'm looking at it from the builder's point of view. Yes, he's got himself a lot, but that lot may be more expensive to build on than it may be worth. That's one application, right? I'm not a civil engineer, I'm a mechanical engineer. I know that there's a big difference between theory and application, just like the law and
So-
reality.
My client is here if you wanted to ask him any direct questions on that point. I don't know
Yeah,
that it's
I
relevant to
will
it, but
when
if,
I will when I have a chance.
that's fine.
But I just wanted to get this clear. But we don't have any, like a fence or anything to mark the differences between the two lots at this present time.
There's some surveyor ribbons or other markings.
Yeah, so the homeowner on Sherman Avenue took it upon himself to may think that that's part of his property, and he's mowing the lawn.
I can assure you that's not the case, and again, they didn't own it until today.
I
so-
don't know.
And we also point out that when the garage was rebuilt in 55, they didn't push it back. And if you look at the two surveys and match them up, they really don't line up that well in terms of any specific utility.
Mr. Chairman,
Sure, go ahead, Mr. DeChico.
Mr. Fatigliano, if we boil this down, is it fair to say that the dispositive factor to consider here is the use of that flat part of lot 28, whereas if it was abundantly clear, in one hypothetical example, that 434 was always using for many, many, many years the back end of lot 28, that would, in essence, go to the idea that the lots were cojoined, or if it was abundantly clear hypothetically, that they were never using and never stepped foot in that part of the plot, that would indicate that the lots in fact were separate. Is that really what we're trying to determine here, is make a determination on the use to then get us to whether the lots were cojoined or not?
I think that's a fair assessment, okay, for it, because the other standards are met, lots on 2 streets, proper depth, et cetera, for it. And I think you could imagine that if there was a in-ground pool that straddled both property lines, that would be a different kind of case for it. If everything was all, manicured the entire lot, that would be a different case for it. So I think you're correct that, perhaps the only area of concern that you would have to overrule the building inspector on is his view that the use was de minimis for it, because I believe the other conditions are satisfied.
Thank you.
Ms. Novak, you have any questions?
Do you happen to know if the shed that is depicted there, again, I apologize for my over-enunciation, do you know if that was a legal shed?
It was not a legal shed. There's no permits for that.
Do you have any other questions?
Nothing.
No? All right, Mr. Dorr?
I have no questions, but I do want to bring up the fact that, for the record, that we did receive a letter from Hazel that resides at 420 Sherman Avenue, that she doesn't want to see the house built on that back lot, and she agrees with the appeal, or disagrees with it.
Do we have that letter? Oh, okay. So we don't have a hard copy of it? I wonder if we should, do you have it in your phone?
No, I gotta put it back in.
Oh, all right. You may have to get it later. We'll see how that goes. Mr. Lapazos?
I'm just trying to get a sense of the history of the property in terms of its original existence prior to 1958, and I know I had characterized the property earlier in a question I asked of the appellants, whether or not the property was 2 separate building lots. And I should have broken the question up into 2, so I'm going to break it up into 2 for you, so I don't run into the same problem. Prior to 1958, when the 2 parcels were owned, they were 2 separate building lots. I'm sorry, I said it again. There were 2 separate tax lots, is that right?
So in the prior application, we submitted the copies of the deeds, and the Warren Avenue side was acquired by the homeowner on 434 by way of 2 separate tax lien sales from the town of Mount Pleasant for it. And that's why it maintained 2 separate tax lots even to this day.
Okay. So at that time that they were purchased, prior to 1958, by one common owner, that owner could have conceivably sought to build on both of those lots. Is that right? Not that they would have necessarily
prior to
gotten
58,
approval,
yes.
but they could have sought to do so because they
Correct.
were 2 separate lots. They were never
Correct.
one lot. Is that right?
Correct.
Okay. So the way I understood the appellant's argument, they're suggesting that automatically, by operation of law, those 2 lots that were always separate lots became one lot for legal purposes as of the enactment of the building code in 1958. Is that your understanding?
That's not my understanding. There is a provision in the code. There is no merger provision in the code, but there's something relative to undersized lots that gives an opportunity for a development of some undersized lots. And that's the code that they're referring to. But that also talks in terms of contiguity, okay? And one of the cases we pointed out is that where you have an L-shaped lot, where you have certain other factors, for the purpose of law, they're not even contiguous or adjoining for the purpose of zoning purposes. They may touch,
That is
but for
their
the
argument,
purpose
though.
they're here to address their
No,
argument.
no, I
That's
know.
the way I
I'm just
understand
trying
their
to
argument.
break it down so we
That's
can
the way
go
I
step
understand
by
their
step.
argument.
Okay. So if we accept that argument, your argument in contradistinction is that whether or not those properties could have been deemed to have been legally merged by operation of law, because of the application of the back-to-back split doctrine, that operation of law did not, in fact, merge those two properties. Is that your position?
That's partially my position. I also think the fact that there was an existing residence at 434 is a key factor in terms of how that section of law should apply.
You want to elaborate on that?
I think the expectation was that if somebody was trying to get a permit on a lot, okay, you'd have to look around and see what was going on for it. To the extent that the house pre-existed the zoning code built in 1920, okay, in essence, it's not to be merged for it. We also think that the intention of the code, we can't prove it, was that it was side-by-side lots and not back-to-back.
So, based upon common law, case law that you've referred to, application of the back-to-back doctrine would have prevented the property from being merged by operation of law based upon the enactment of the code in 1958. Is that your argument?
I'm not going to wordsmith prevented, but I understand what you're trying to say, yes.
So, as a part of your argument, you're suggesting that whatever use was made of the rear lot by the property owner, who again owned both, that use did not transform the separate building lot, lot 28, into a part of 434.
That is correct.
Okay. I have nothing further. Thank you.
Is there anyone here?
Do I have an opportunity to, just a minute?
Yeah, Mr. Chairman, I'd like to hear from them now that we've heard from Mr. Vitagliano. I'd like to hear from the appellants.
Sure.
Whoever wants to speak, you want to both come up? Why don't you both come up?
We can both do it.
Yeah, because we may have questions for both of you. You both presented so well.
We're
Yeah.
trying to work through this, all these ideas, which we're very happy that you're considering them this way and articulating. To the question of the permit, I think it's, there's a question of the relevance, because we're talking about the usage of the property. When someone's required to get a permit, you're required to go through a process, get a permit, build a structure so that it's a safe structure, it's got the right boundaries, but it's still, the intent and the usage is still there. So whereas they probably should have paid a fine, I think it doesn't diminish usage. So let's just, that was my response to your response, and maybe you have some thoughts on that as well. The fact that they didn't get a permit shouldn't affect the usage question. That's just one thing.
Yeah, but let's just keep it to questions from the board to the appellants. So if we could direct questions, then we could get a clear record.
Okay.
Anyone have any questions?
Excuse me one moment.
Yeah.
Mr. Lopatos, I have to take care of something. Would you run the meeting until I come back in about 5-10 minutes?
Would you gentlemen like to take a brief adjournment and we'll reconvene in about 15 minutes?
I
All right, if you don't mind?
Whatever's work.
Yeah.
Yeah, whatever you.
Yeah.
Sorry it's taken so long.
No.
It's all right, you're the applicants, so you can agree to the,
We're going to take a 10-minute break.
Thank you, Mr. Chairman.
All right, and then we'll get back to this.
Come off live for a second?
put a delay. Yep, let's
Okay,
go for it.
all right. Can I just say something briefly before you ask a question? 30 seconds. Mr. Vitagliano refers to a L-shaped lot. Not sure, this is, I should have had a Sharpie. This is lot 34. This is lot 28, to the best of my ability in Photoshop. I know it turns right here, but I'm not sure where the L shape is. Do you see an L shape? Please enlighten me. I think a lot of this actually breaks down to, I think the attorney, maybe, I don't know whom, is thinking that the rear lot is just the hillside. Because in fairness, he did say, because of the topography, there's no utility or value to the rear lot. I don't know that everyone quite understands that this is lot 28 as well. It seems strange.
I disagree. I think that was clear last time, and I think that you made it even more clear today.
Okay.
I think we've gone over that. So
All right. Thank you.
I don't think that that's the particular.
All right. Do you have any questions for either of us?
Ron, did you have any questions?
Does any other board members have a question?
I would, but I would defer to, nobody else on our board has any questions?
Not at the
Not,
moment.
Adrian, do you have any questions?
Not at this time, you're good.
Not at this time. You or George?
Okay. Just to go back now, I'm going to ask you the same questions that I asked the attorney for the party who benefited from the decision that you're challenging. With respect to the property at issue prior to 1958,
Yes.
when it was purchased by the common owner, it was two separate tax lots, is that right?
Yes.
Okay. In addition, at that time, if that owner wanted to build on both of those lots, subject to any variance they might have required, they could have done so. No, it's just that, I'm just trying to get a sense of what your position is with respect to several fundamental questions. So I'm just asking the same questions again that I asked prior to see if there's a disconnect or if there's some kind of
And I would
disagreement.
add to that 21879A in the 1958 code, which I happen to know because I've been over this a little bit, requires where you have two substandard lots that are touching each other, they're merged by operation of law.
I didn't get to that part yet, but I'm going to ask that next, because
Yes.
that was, again, the third question that I asked of the,
And in
Mr.
fact,
Vitagliano.
in the April 10th meeting, Mr. Vitagliano did say, well, that code is there, we're not disputing that, however, back-to-back split.
okay.
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 What was your next
Right,
question?
sorry.
Yeah, I didn't get to it yet. I'm going to try.
Yeah.
Okay, so now, at the time, again, that the lot was commonly owned by the original purchaser prior to 1958, it was two separate tax lots, one person bought them.
Yes,
That person owned them.
yes.
That person didn't build on both of them and only built on one of them. The person who owned the two lots prior to 1958 only built upon 434 Sherman, didn't build upon lot 28.
Yeah, the deeds.
No, I'm just going to try,
I'm answering your question. The deeds, I've only looked back as far as 1950 when they were owned in common, but the house was built in 20, so I don't know when,
Right.
when a house was,
lot 28 was never built upon. Do we all agree on that at least?
yes.
Okay. Now, we have these two lots, commonly owned. Only one was built upon.
Yes.
Time goes forward, 1958 occurs, and now your argument is, by operation of law, the two lots now become one lot, they merge by operation of law. Is that your argument?
That's one of our arguments, yes.
But is that an
Yes,
argument that you're making?
Yes, that is our argument
Okay.
we are making, yes.
Then the argument that the party who benefited from the decision that you're appealing here today, their position is that that did not in fact occur, that there was no merger, because they're relying upon a doctrine in common law, not in statutory law, not in our town code, but a common law, a legal creation by the courts that applies a doctrine called the back-to-back split doctrine, which would have made the merger by operation of law that you're relying upon not applicable. Is that right?
Which has been challenged and questioned since then.
But is,
As I
I'm sorry.
I just keep trying to just
I'm
get
sorry.
very simple yes or no questions,
apologize.
and I can't get a yes or no answer.
What
And
is your-
I'm not trying to give you a gotcha. I'm
Right.
really just trying to build a record.
All right.
It's just very frustrating.
I'm sorry. Please, you
So,
want to answer?
so with respect now to the lot that was not built upon, lot 28, you're arguing that lot 28 was utilized by the owner of 434 in some ways that made the use of that lot sufficient in terms of its materiality, fire pit, picnic table, I think you made reference to a gazebo.
Yeah.
You're suggesting that that usage was so significant that it enabled the owner of 434 to have used that lot as a part of its own property, that that lot was no longer a separate property, that it had become, by its use, a part of 434. Is that right?
Yes.
Okay. So if we accept those arguments, that the use of the property, because of these picnic table, shed, gazebo, and fire pit, those four things,
Of that, yes.
the problem that I have is that, and I remember this from the last time we had a meeting, is that there was a real lack of significant detail with regard to the amount of time that those features were utilized, when they were put on the property, how long they were utilized for. None of that came out in the first hearing that we had on this application, and none of it came out again today. So I want to give you the opportunity now to make the argument better than what we have on the record presently.
I can say, I would respond to that by saying that it was maintained as a lawn, as far back as my mother can remember, mowed and maintained. There's a small rock boundary that separates her property from that property. If maintaining the property by mowing the lawn is an indication to me that there's usage and an intent for usage. I mean, it's impossible to have a specific evidential record of every single year of the use of that property.
I don't know what's possible or impossible, but I'm asking you to do the best you can. That's all. I'm
This
not asking you
photo
to
from
create
2016.
something that isn't there, but I am asking you again, this isn't about adverse possession where a property owner can claim right to other property
Right.
because they've asserted.
Can I ask
Their
you a
own
question?
use of
Can I
it.
ask you a question about that?
That would kind of be improper, but go ahead.
All right, how long would it have to be used for you to be satisfied that it has utility? Can you give me a number?
I don't know that that's the.
No, I couldn't give you a number. And I'm
Okay.
not asking you
But
for
it
a
is-
number. I'm
the
asking you to
question
do
is
the
about
best that you
utility
can.
and value.
But why are we talking over each other?
I'm sorry.
This is very frustrating, very frustrating.
I don't wanna make you angry, I'm sorry.
I'm not angry at all. I'm just frustrated because I'm trying to help
Okay.
all of us have a record that's going to be reliable for the purposes of today's proceeding and any future proceedings on this application, depending on how the decision of this board comes out. And what I just want to make a determination on is, again, whether or not we have all of the evidence in the record that could have been put forth to establish the significance of the use of the property, lot 28, by the owner of 434, because that was the argument that you were making earlier. And I pointed out that I thought there might have been some additional information that you might have been able to provide, and I'm offering you the opportunity now to do the best that you can
Right.
to supplement the record in that regard.
Can I respond?
Please.
Okay. You have the statement from my mother that she sent a letter into the town, signed in her name. You have my statement. You have the statement of Kevin Hopkins, who lived up above there. And you have the statement of Tammy Stephen, if I remember correctly. You have a photo from 2016. Yeah, that's all we've got.
Okay.
I mean, I've got 2016. I could probably go back to an aerial photo from 2005. I mean,
Yeah, I mean,
we're
anecdotal
not-
evidence.
Yeah, I mean,
I expect anecdotal evidence. Of
right. I'm
people
not
talking
sure-
about their observations over time. That was really what I was looking to elicit, not aerial photos from any particular years, although that could have been helpful. You have what you have, and that's fine.
Short of family video from the 90s, which I don't have,
Yeah, personal recollection would have been fine. Like I
Yeah,
said, anecdotal evidence from your own observations and experience
Right.
going back a certain number of years. The shed was there for 10 years. The fire pit was there for 20 years. They always used it, something to that effect, that's all.
Oh, okay, well, in that regard, there was, about 15 years ago, there was the screened-in area that Mrs. Zachansky used to sit in. And my mother, as she described in her letter, that was there, and she would like, the children put that out there for her, to give her something in the backyard to sit in. Probably, to the best of my recollection, about 20 years ago is when that shed went up. There was also a snowmobile next to it and wood stacked next to it, because it was, the big shed that they put in back there. The, 2 snowmobiles, thank you. The picnic tables that are there have been moved around and used at different times. They tried to make it kind of nice for a while, I think for their mother, Mrs. Zachansky, because she was getting quite a bit older, so they put in the fire pit and they put in the chairs probably 15 years ago, because she's deceased about 5 years and she was in her 90s. They also put up a gazebo. They stacked wood back there. We actually asked, I forget his name, there was a nephew or something that was living there a couple of years ago. There was a rack of wood that was right there on the property line, right here, and I said, well, it's rotting. Could we get rid of that rack of wood? Because it had been there for many, many years and was rotting. To the best of my recollection, that's, having lived right there next to them since 1978, to think that they wasn't used, because again, the third stipulation, because a lot was said about back-to-back split. This case, this case, this case, this case. Yes, and he said himself, the third stipulation is never used in conjunction with the other lot, or that they're L-shaped and they're not used in conjunction. And we maintain that they were never used together, which frankly, I think is patently absurd.
I have no further questions, Mr. Chairman.
Is there anyone else here who wishes to be, speak?
We have a woman with her hand up, Mr. Chairman.
No, I can only say,
Ma'am?
having lived there for
Ma'am?
47
Yeah, I'm sorry.
years.
Is she able to come up and, or at least,
Yes, come on up. Come on up. You could swear in. She's only 9.
if you want, we could bring the microphone to you. You're doing just fine, so.
I won't need the microphone.
All right.
Just, Mr. Chairman.
You swear to tell the truth, the whole truth?
I'm
and
sorry,
nothing-
I can't hear you. And may I just say, I know I'm out of, and I'm not gonna make a big deal. I think that you do a big disservice to the people who come to hear you when you don't speak into your microphones so that people can hear you.
Well, I'm talking to you now,
No, I
and you
can't
still
hear you.
don't
No.
hear me. So out of respect to you,
Aren't we supposed,
I can only
aren't
talk so loud.
we who sit there supposed to be hearing what you are discussing so that we can hear?
All right, you had something you wished to say.
All right, I beg your pardon. I don't want to be a problem. But I've lived there for 47. I'm Helen Rubio. I live at 438 Sherman Avenue. That's right next to 434. And our properties abut each other. They go from Sherman to Warren, both properties. I've lived there since 1978, and in the very beginning, there was a family there, the Zachenskys. They used the backyard. There were 3 boys who were still living there. I always thought that was their backyard, and it was only not too long ago that I found out that it wasn't really supposed to be used as a backyard if it was another piece, another parcel of land. So that's all I wanted to say.
Okay, well, thank you.
And the, things that were back there were all the things that you would expect families could do. The shed, the snowmobiles, the fire pit, the stacks of wood, the little gazebo that their mother put up so that she could go out and have tea. To me, that was their backyard. And I'm assuming that that was correct. I'm only here to verify what my sons have already said.
Okay,
And I might add, and this is all I'll say, we have no intention of trying to do the same thing, of selling a piece to have a house built or whatever, or to have a house built on the back of my property. I like it the way it is. I want it to go to my children, my grandchildren if possible. And it's just a source of my protecting my peace and an investment.
okay.
So thank you very much for letting me speak. I'm sorry if I was a little quick.
You have every right in the world.
Very good, ma'am, thank you.
You know, George Burns once said, at his age, when a woman steps into the room, he has the right not to stand up.
Yeah.
So you have a right to say whatever you wish to say.
Any further comment, Mr. Chairman?
I'm just trying to think of where we can go from here.
See if there's anybody else that wants to speak.
Is there anyone else here who wishes to speak on this subject? Mr. Vitigliano? Yeah, that's much better.
Just one more thing. I have an old survey from 1962 for the property. It shows some retaining walls. It shows no fences on it. Fencing your property would be another example of using them in common for it. So I'd like to at least put that in the record.
So received.
Thank you.
I think we have that.
Mr. Chairman, I move that we go in, seeing that there's no other speakers, move that we go to business session to discuss this further.
We already have that document. It's in your letter of March 17th, that survey.
I'll second that application, Mr. Chairman.
Okay. Ms. Novak?
Aye.
Okay. Mrs. Chico, you want to go, you were doing it? Mr. Dorr?
Aye, business.
Okay. Let's go into business session. During this business session, there's no dialogue between the board and the public or the applicants, okay? I have two problems that go through my mind. And one is the building, being able to build on the property, and also the fact that I just did a little something here. You have to have a 30-foot frontage on Sherman. That brings you pretty close to where we have that drop-off. So you're actually putting the house right in that area. It's a problem. The other problem I have is that the people that now own this property may in their own mind think, even though there's little flags there, that since nobody can build, that they'll mow the lawn, they'll do the maintenance on it, et cetera, et cetera. And the other problem is that the property has been used, we've had dialogue on this, that the property has been used as a continuous piece since the 1950s, or even before that. Now, the difference is, now you have to correct me on this. The Rubio property has two tax lots, two tax bills, and one lot,
One deed.
one deed.
See, I don't think that was actually that significant. the fact that one property was purchased, one collection of two properties was purchased with a single deed, and one collection of properties was purchased with two separate deeds. I don't think that that has a significance to decisions that we made or that the building inspector made in his challenged decision. Although I do recall that that came out during a hearing.
Yeah.
Also, Mr. Chairman, I'm not sure that the idea that if it is considered a distinct lot that they could build on, if they might need future variances, I'm not sure that that necessarily factors into our decision.
Yeah. See, in
Tonight,
fact, what I,
yeah.
I agree
yeah,
with
what I
that too,
think,
whether it's a building lot or not, that's a planning decision.
right,
So, I mean, I don't think that's what's in front of us.
right. And I think we have two issues to discuss. One is whether or not the discussion, the argument about whether or not a back-to-back split doctrine is still applicable in 2025. There was some argument, clearly it exists in the common law, and it's existed into, I think, as late as, we had cases, I think, that were in,
I think there were 2014
2014?
cases for the precedent, yes.
okay, so I'm not of the mind that we should now make the determination that the courts would no longer endorse that doctrine. It may be something that's to some extent disfavored, but it clearly is not overruled the common law that established the doctrine. So I don't think that the back-to-back doctrine, back-to-back split doctrine is no longer applicable to the property if we make the finding that the use of the property conforms with the standard that was set forth by the courts. That's where we come to the issue of whether or not the use by the 434 owner of the rear of its lot, lot 28, was so significant that it prevented the application of the back-to-back doctrine.
So if somebody could explain this part to me. If we determine that the building inspector was correct in his determination, where does that leave the current owner of both lots as far as what they now own or not?
Well, there isn't a common owner anymore.
No, not a common, no, the current owners of both lots.
Well, the person who bought 434 is
Right, the-
caveat emptor. I mean, you know, they bought the property if they thought something other than what I'm assuming they got a survey. I'm assuming it had
Right, but
a lot line that was
430
drawn for them, and they know what
434
property is theirs if
Right.
they looked at it.
434 on the lot line should show them that their lot is
Yeah.
basically ending right where the garage is.
It would have to. If
But-
the survey was done by,
But if
proper
we say
surveying
the building
technique.
inspector is correct, have they now just acquired an additional?
no, we're not talking about adverse
They don't
possession.
own it.
We're
They
not
don't own
talking
it.
about adverse possession. We're literally talking about whether or not the back-to-back split doctrine applies.
Yeah.
That's it. That's the reason why we're discussing the level of usage by 434 of
If
28.
we say that it does not apply.
If we say the doctrine doesn't apply at all, then we have nothing to talk about.
Right. But if we say, if we determine that Joe is correct, and that the back-to-back split applies, because there was no, essentially, like my question, Mr. Vitigliano, was that the amount of use, if we determine it was a lot or a little, Joe said it was de minimis, if we agree with that, we're saying that it's two distinct lots, because the use was de minimis, and therefore
But
it's a
remember,
separate,
though,
it's a separate lot.
The argument has to flow in order. First, we have to decide whether or not the back-to-back split doctrine is still available. If we find that our decision of
But
the
I
board in
think it-
2014 and
I think you even go back before that to say in 21879, the law that created the ability to join. Because that language in there does say they shall be joined. So we determine, is that applicable? And then if that was applicable and they shall be joined, then there has to be something to say, well, that doesn't apply in this case. And what would say doesn't apply in this case was that we bring in the back-to-back split concept, which is that there's frontages on two streets and the lots are
and
there
the
was
only
there was a
requirement
use-
that's in dispute is whether or not the usage.
Right, yeah.
So again, the first question we should probably assess is whether or not we believe that the back-to-back split doctrine is still an available, not making the determination yet whether it applies to this property, but whether or not it's even legally available.
We don't know
I,
that.
I think that it
Yeah,
does,
I think it
but
is.
I'm now deferring to everybody else to have a voice on that.
I think it is.
Well, we're assuming, so the laws constantly change and they get adjusted. And I don't, we'd have to research to find out if it's still applicable.
Based upon the evidence that's been produced before us, adduced into this record, we have no basis to believe that it's not good law. We have to,
And what about the fact that the property was continuous use?
let me
How
just
does that-
clarify one thing. There was argument from the appellants. They made references to dicta in a court decision that the back-to-back split doctrine was disfavored. There was argument, not that it's overruled, but they were urging us to go along with that reasoning, that we not apply it, because it seems as though the courts aren't as eager to apply it in the modern era as they were 10, 20, 30, 40 years ago. So even though there wasn't evidence in the record that said that it's not good law, there was evidence suggesting to us that we not find that it's applicable. Against that backdrop, I'm still believing that it's applicable here and that it's available for us to apply if we find that it meets the factors set forth by the
Let me
court.
go back to, so, my other question for a second, now to try and clarify it. Hypothetically, if we were to agree with the Rubios, for lack of a better word, that the use of that flat portion of lot 28 was continuous and a lot, and very much met the standard to break the connection of the back-to-back split. And where does that leave the current owner of lot 28? If we say because of the nature and type of use,
They couldn't
back-to-back
build as
split
of
doesn't
right. They
apply.
couldn't build as of right. They'd
Right.
have to have a compliant lot, which they don't. So they
So
would
they
have
could
to get a
variance
variance
to
to
build.
overcome the non-compliance with the
Right.
code that lot
So the
28 currently presents.
And they could still come and seek that, whether or not they get it is a whole different story, but.
But theoretically, right now, the property on, what do you call, it, on Sherman Avenue is not owned. They're owned by two different.
Both lots are owned by two different people.
Two different people.
So
So the ruling of back-to-back is one thing, but you have two separate lots. It's like, for example, if you live on Greenwood and you've got a house on Halsey, right? What do you do there?
I think really what
And
we.
they're two separate owners.
But I guess what I'm getting, also what I'm trying to get to is, we're all trying to get to, but the question to Mr. Tigliano, what we went through is, what this comes down to is the nature and use of that flat area behind 434. All right, picnic tables, gazebos, a shed, anecdotal evidence that they were using it and everybody assumed it was the backyard for a long period of time. I personally think that I take all of that testimony at its word, that is all accurate, and that's what happened back there.
Okay, but that's the second part of it.
Right.
Are we reaching that part yet?
But
We've
I-
already decided the back-to-back split doctrine is applicable and
I think
available
most
to
of
us?
us feel it does.
Then we can go to that
Yeah, I
factual
think most of
question.
us feel that it does. It is available.
But I just want to be
Yeah.
sure that we've all,
I mean, I heard Adrian say yes,
I
and
did
yes,
agree.
yes.
Hey,
yes,
Ron.
yes, yes.
Right.
back-to-back split is available doctrine?
Yes.
Okay.
All right, so,
Factual
right, so
question.
we're all
So
on.
all the requirements are met except for
Well, no, but
the
what I'm.
contested issue is whether or not the use of the,
And I think factually, I don't think that there's a dispute as to whether or not what was represented was going on back there was going on back there. I feel confident enough by all the testimony that is a true and accurate
it was
representation.
uncontroverted.
Right.
Nobody challenged it.
The question for me is that's, even if taken at its word, is that still enough to meet
That's
the
the
threshold or not?
Is it enough?
And we don't really have much guidance on that particular point.
It's a very fact-specific question, and every case obviously is going to be based upon its own facts. So now, again, you know, the best evidence, we have the evidence we have. So, based upon what we have, was that usage intense enough? Does the record reflect that it was intense enough to have altered the ability of that property to have the back-to-back split doctrine applied to it.
I think to that effect, what I'm struggling with is the word never versus de minimis use. I think that's where I'm
Well, de minimis, by its nature, it's a very vague
You know, you
term,
gotta-
and in the decision, it wasn't elaborated upon, so we're left, I think, to do that on our own.
Yeah, but define de minimis. It could be, what is,
It's a conclusory statement by the building inspector in his decision, and it wasn't, again, factually,
but maybe to the Rubios, it's not de minimis.
to any person, the evaluation of whether or not it was de minimis might vary, but because it's not a term of art that applies to the standard, I don't think we should get hung up on whether or not that wording in the building inspector's decision dictates what we can find based upon the record that's been adduced before us regarding the intensity of the use
I think,
of lot
I think
28.
if we flip it, I think we should, the analysis, maybe the better analysis for us should be, was the use that's on the record, established on the record, substantial enough to consider it as one entire lot as opposed to.
But remember, it's not a question of whether it's a question of whether or not it undercuts the application of the doctrine. Do we have a copy of that case that was provided with, that had the standard laid out? It's in the file from the maybe original hearing. We had a series of cases that Mr. Tigliano gave us. I think it's in this pile here. Is there a sign?
It's probably in Aldo's original application, not this one.
You want to ask Mr. Vitigliano
No.
which case it is?
Nope.
So we could point this right to it. It's in somewhere.
Just want to get the exact language. Well, without the case law in front of us, we can't use the exact language that the court used, but again, our recollection is that it pertained to the intensity of use, to the point where it established that the two lots were no longer separable. They were viewed as one single lot.
If we go back to what we said before, according to the law, it's two separate lots. According to application, it was treated as one lot.
That's the,
And that's your
Not
contract.
sure about
that's the factual issue we have to decide, is whether or not it became, in effect, one lot.
That I don't know.
It started as two separate lots.
It might be here in this one.
No, I think it started, even though it was bought as two separate lots.
There was two separate tax
Yes,
lots
they're two separate tax lots.
when they were purchased
Two
by the
separate
common owner.
deeds. Two separate deeds.
That's right.
But over the years, it was used as one lot.
Well, that's the argument that we have to evaluate.
Right.
to clarify on the language that I was looking for, it doesn't look as cited that it's never, it's not used in conjunction. Never is a little different than not for me.
Right, this is,
Yeah, in that letter.
Well, if we marshaled the evidence of usage, we had references made to, at a certain point in time, there was a wood pile. It sounded as though the wood pile may have been put there at one time and then was not necessarily replenished or used to supply wood. I think there was reference made to it being rotted. So at one point in time, there had been a wood pile on the property. Then there was reference to a shed. The shed, I guess, did not have a permit, so it wasn't a legal structure, but do we have any testimony regarding the nature of the shed? Was it a plastic shed that could be picked up and moved in a matter of minutes, or was it a shed with a foundation? Did we ever hear anything about that in the record?
I don't recall.
Anybody recall? Nope. Okay. What was the third thing that we had? We had a reference to a gazebo.
gazebo.
Does anybody recall whether or not the record reflected the time that the gazebo was there for, when it was erected, how long it was there for, how often it was utilized?
No, we had a testimony that the picture was from 2016, I believe. That was,
Okay, so we know it was there in 2016. And
Fire
we know
pit.
that somebody liked to drink tea there.
All right,
Anything
I
else
don't know.
anybody
I'm gonna-
remembers about it?
I'm gonna try and move the ball down the field a little bit here. You know, I think if, for my interpretation from the last meeting and this meeting, you know, I think to me, it's fairly clear that the back end of lot 28, the flat grassy part, was used in all practical ways as the backyard of 434 Sherman Avenue. That's how I feel, and I don't believe that we've had any testimony to controvert that at all. I would think that while we may not have an abundance of evidence and direct and documentary evidence showing how that backyard was used, we do have some evidence, at least anecdotal, from somebody who's lived there for 50 years, family, and we do have pictures dating back about 10 years. So where that leads me is to say that while I feel the back-to-back split doctrine may be there for use, I'm not sure that it would apply in this particular scenario, because it would seem that they were used in common based upon the record before us. So, that's where I'm going.
Okay, and as a result of that,
As a
you're saying
result-
that the back-to-back split doctrine would not be applicable to keep
Right.
this property
In this,
from being
that it
considered
is
to be
something that's
one?
available but not applicable in this case. That's where I'm leaning at this point, which would seem to be that a notion against the current determination of the building inspector, who I respect very
As I also respect that building inspector.
much. I know.
I actually don't think the record was sufficient. I tried
Yeah.
to elicit as much as I could to build it up. I thought that we might be able to get more detail. But it was really just a bunch of fleeting uses over an indeterminate period of time. Very non-specific level of usage. And the fact that part of the property had a lawn that was mowed this past week. There was no history of how long the property was even mowed, for that matter, over the years.
Yeah,
So the record just wasn't there for me, and I would find that the back-to-back split doctrine would be applicable. That's how I'm leaning right now.
But all of the information that was presented tonight, a lot of it was hearsay information. So we have to assume to a certain degree that that information is truthful. And if it is truthful, then your theory that the doctrine exists, is applicable is false.
Well, Mr. Chairman, I wouldn't say that it's hearsay. I mean, I think people, to the extent, and I would agree that the record is not as developed as I would want it to be necessarily, but I don't believe it's hearsay. I think people were giving you the direct observation.
Oh, no, I don't mean hearsay
Yeah.
in that respect. We're going by memory of what the people who have lived in the area have done.
You're correct, Mr. Chairman, but it was consistent.
Yes.
It wasn't like one person said one thing or another thing.
Exactly.
It's been consistent testimony on both sides.
And there was
That was
not-
uncontroverted. There was no challenge to
no
any of it.
challenge to any of it.
Nobody challenged a single piece of the evidence of usage.
Well,
Just, the quantum of it is the question.
No, and that's everybody's,
So the question is, what occurs if we say that the back-to-back doesn't exist? I mean, it's still, from what I can tell by the record, there's new owners of one piece, that's a lot, and there's another lot that has an owner. So by us saying that, where does that leave?
Yeah, but should we really be looking at that? I mean, I understand that
Well,
it's a curiosity
to me,
question, but
well,
whether or not the
yeah,
builder can build on it with a variance somewhere down the road if we, overrule the building inspector, shouldn't be a part of our calculus here.
But I'm also looking at the initial owner. Prior, on our initial testimony, it was 2 lots owned by one person. Testimony is also saying that it was 2 lots owned by one person, now using both lots to their advantage, because they own both lots. So I think we can all agree that that initial owner, pre-24, was utilizing both their lots. They own both lots. Regardless of where property lines were, and we're looking at to use, whether it's a small piece, de minimis, whatever the English language is telling us, they used a fraction of that piece of property. So if we go back to the, and I'm going non-legal, I'm just pulling stuff together here. Whereas if we say the back-to-back didn't exist, that it was considered as one lot, you follow where I'm going? No.
You're saying.
No, I follow everything you're saying. I'm waiting for the
Well,
next piece
right,
to
I'm trying to figure
reflect
out
your view.
whether we decide yay or nay, where does that leave the world at this point?
If we,
Benefit either side of the equation here.
if we affirm the building inspector's determination and deny the appeal, then the current property owner of 28 has an as-of-right opportunity to build upon. If we overrule the building inspector's determination and we grant the appeal, then the owner of 28 has a property that he cannot build upon as of right. He may choose at some point down the road to try to get necessary approvals to get that non-conforming lot to become a lot that he could build upon. But
that
again,
flat-
it
right,
shouldn't
but that-
be
that
part of our
flat part-
calculus.
Right, but that flat part of lot 28 still remains part of lot 28 regardless of what we decide.
Correct. And that's just a lower piece, because there are flat lots above and below. I mean, we looked at the property from both sides of the property.
So, again, I think this boils down to do you think that the use that was put on the record is substantial enough
Yeah.
or not to make you comfortable in determining that it was used as a common use or co-joined use or between the two, or not? And
I think
you may
urban-
feel it does or doesn't. I think it's
Yep.
probably.
let me throw this out. We have the lot on, lot 28 is vacant at this point, correct? The lot in front of it has been sold to a party. So basically speaking, lot 28 stands by itself, does it not?
It does.
So the question comes up, is lot 28 a buildable lot? Forget back to back.
Which is not.
Depending on our decision today, we'll make a determination whether it's buildable as of right or potentially buildable if a nonconformity could be overcome through a variance that somebody may make someday.
the fact of the matter is, if we take a look at the, and we have to also look at the topography of the property. You have to,
I don't
to
think
some
we
degree.
should.
To some degree.
Yeah.
To some degree. Is, if you figure a 30-foot frontage on that property, and you still, you'll have your, the 100 feet or whatever it was, I forgot it. You'd have enough for the side yard setbacks, but it's your depth. And theoretically, if we denied this back-to-back, then the builder has the right to apply for a permit, go through the process, permit, zoning, so on, and build on the lot. Correct?
Yeah, but he would still need to get.
Right, it would be a non-conforming
Variance.
lot though, so
Yes, he
he
has to
would,
get variance, but
he's-
it's not a back-to-back application. It's a single lot of 5,000 square feet bordering on that one street, and that the one on, the exists, where the house exists now, is a total separate entity. Is it not? He doesn't own it. It was sold.
the properties are separate, that's correct.
Yeah,
I
so
agree.
that property is sold, so whether it was, the individual now that owns that property, he may go out and do the lawn in the back at the present time, that's fine. But the fact of the matter is that the lot, the other lot, 28, may be still a buildable lot, but that the builder will have to go before the building department, to the planning board, to maybe the zoning board, depending on how he does it.
Albeit that issue isn't before us, but yes, that appears to me to be the way it could work out. But again, that's not, it's not a factor for us to take into account whether or not the person who benefited from the building department's decision could still salvage some kind of
He's gonna salvage it
money
anyway.
out of this property
No.
that otherwise would be
But he's gonna salvage it
non-conforming.
anyway. He can still build on it. He doesn't own the first lot.
Yes, it's just
Okay.
that we shouldn't be,
So the
we shouldn't
back,
be looking at that.
so
That's
the
all. It's
back-to-back
not,
basically doesn't exist. It doesn't.
the
because-
back-to-back doctrine application only applies to determine whether or not the lot is buildable as of right. That's the question that the building inspector decided in his challenged decision, and that's the decision that we have to review based upon the applicant's appeal.
And in any lot that's buildable out as of right, they still have to build within conformity to the, otherwise in conformity to the code. So if they can't do that based upon the topography of this particular lot, and they have to build the house differently than the code otherwise says.
It's not even
then
the topography, it's the size of it.
the size, topography,
Yeah,
everything.
the size of it is non-conforming.
Right.
And it would be a non-buildable lot, subject to the possibility that variances could be obtained that would make it.
I mean, I agree that, I personally like to know the big picture as well, but I don't want to get stuck on all of those things, because I don't think that's the focus. It's important to understand, but it's not the focus. I don't want to focus on.
One last question. You mentioned that the appellate courts have sort of not looked favorably on these back-to-back things. So what we're looking at is a change in, I'll use the word law, I don't know what the right word would be, but, or attitude of the court. So the court is now saying, we don't really want back-to-back applications. Correct?
I'm not
That's
I
what you
think,
said.
I think the better way to say it is, the courts in the past have recognized the application of this doctrine, which was created by common law. Courts created it. It's not in any of our code. And courts over the years have applied it, and more recently, the courts have said, we've applied this in the past, we're endorsing that it's still legally available as an option, but we don't love it. And the viability of it into the future may be subject to question, but they haven't gone to the point yet of saying it's no longer applicable moving forward.
You can't,
And we
yeah.
don't concern ourselves with what the courts may do someday. What applies right now is the law today. And the law today allows application of the back-to-back split doctrine under case law which created it.
You're more adverse at this.
No, I'm just trying to crystallize, but again, it's a factual question. Everybody's evaluation of the record is gonna be,
The question is if they were, if 434, if it was all wooded behind, if that grassy area where the gazebo was and the picnic tables was all wooded, and you told me that over the years that they would walk back there and the kids might go for a hike and you know, go play around, like, to me, not so much. But when you have this flat, distinct parcel of land that objectively to the casual observer looks like a backyard, and we have testimony that for decades has been used as a traditional backyard in every sense of the word, then to me, that crosses the threshold to say that it was, the two lots were being used in common. To each his own on that, but that to me, yeah.
and
Yeah.
as much as I respect you and your evaluation of facts, we can have a
Disagreement on it.
disagreement on how those facts add up.
Right, but I think we
again,
need to,
I'm
I
just
think, but I
basing it
think
on-
at the end of the day, those are the facts to consider and.
Again, most of them are uncontroverted.
Yeah, and beyond that, it's like
So,
we're kind of spinning the
It's
wheels.
just,
as
yeah,
it
it's just a
sits.
question of whether or not the four things that were on the property with the
Yeah.
record developed as far as how they were used
It's a,
is
the
enough
fact-
to,
it's the weight you, those are the facts I believe we all agree with. How much weight do you want to give those things? I think we need to make a decision now or adjourn for decision only and come back and think about it next month. But I'm ready to make a decision tonight. For me, so I don't know how.
I gave you my
everybody else is.
indication of my
Yeah.
ability to make a decision tonight as well. So
Yeah.
we can both be comfortable if our other members are ready, making a decision or not.
Right, so I think if you guys want to think about it, we could adjourn it. If you want to make a decision tonight, we do that, but.
The only problem I have is that you haven't convinced me that they're basically two separate lots. You've convinced me that they're one lot, that it's one lot, or two lots used as one lot.
Well, I think, Adrian, did you want to say something? Sorry,
Kind
Mr.
of
I
where
thought you were done.
Herb was going earlier with they're two separate lots and the difference between using them in conjunction versus I own this and this is what I have here and I own that and this is what I have here.
Can you say that again?
So because they were two separate lots and he owned both, he could place what he wanted on either. So is that using it in conjunction, is your argument would say, versus I own lot A and this is what I have here and I own lot B and I can do what I want with lot B too. Versus your argument that they were used in conjunction as the backyard.
Well, I understand the point, but I think when you look at it, like I said, I
Your argument,
think
it's in
the
conjunction. I
way
get where you're
that
going.
it's situated and the nature of the use was connecting the two. It wasn't, if there was some distinct use within lot 28 that really had no connection to 434, I could see that point, but to me, that the uses were clearly, like there was, the backyard, it was used as a at the end of the day, that was used as a backyard for 434. It wasn't used for anything else, and that's where I'm at.
Well, the question comes up, do we make a decision?
I'm comfortable making a decision tonight. I think Nick is comfortable making a decision tonight. I don't really have a sense yet about Herb's readiness, your readiness, or Adrian's readiness.
Right.
But if we want to discuss that now, we can, as Nick said, either make a decision tonight if our other three board members are ready, or we can put this over for decision only on the next board hearing date.
Because the way I look at it, I have to agree with Nick on this particular application. And though I'm not a lawyer,
You don't have to.
but no, but there's common sense.
You don't have to.
There's
Well, that-
common sense.
Maybe it's better that you're not a lawyer.
We don't.
No, but basically speaking, we have to look, there's two ways of looking at it, like I said to you before. From a legal standpoint of view, and from a common sense point of view. You know, just to give you a stupid example, the no bail law. It's a great idea, but it's terrible, okay? So we have something here, it's the same thing. Reality is one thing, the law is another. And the fact that for the last 50-some odd years, or even before that, this family owned it, going back to when the lots were subdivided and originally purchased, it was used as one lot. So the question you're saying, well, let's say 75 years that those two parcels were used as one lot. Now, the property was sold.
We really don't have a record to support that conclusion. Going back to the 20s, we have no idea what happened in the 20s, 30s,
We had,
40s.
we showed here, it was New York Central Railroad, there was a map showing the lots that were set up,
And one person bought 2 lots.
and one person
I
bought two.
100% agree. We have no idea what they did with it.
That's right, but you know they didn't do it because even if you went back 50 years, okay, like the Ruby, Mrs. Rubio had, you go back 50 years, 60 years, you know that it's been used as that particular thing. It has to be some form of a precedent. You just can't say, well, they used it for 50 years and therefore it was used as one lot, and the topography was such that, you know, they just went right up to the stone wall. They used it as much as they could. And over
Nobody
the
stopped
years-
them.
No,
I mean,
no.
in fact, it was one owner, I believe,
Exactly.
all
So
that time. So that owner was using, they owned 2 lots.
They
and
used
they
both lots.
had the potential to use both. We don't know what use was made in the years that you're referencing, but they could have.
I don't know, George, I think the argument is, I'm gonna use the word de minimis here, because it's.
Joe's never gonna use that phrase in a decision again.
But
That I
basically-
can tell you. I'm sure at this point, the last words he wanna hear is, probably Latin in general
We
is
use
out.
it all the time.
He's never gonna use Latin again.
Moritores e salutam, okay?
Herbert.
As they say in math, quo est demonstratum. That's Latin, it's been demonstrated. I think we can spend all night here talking to the point of nausea.
Unless we're ready to,
I'm ready.
Adrian, you ready?
Put a motion up.
Herb, you ready?
Somebody put the motion up.
Okay.
I want to make sure you are comfortable making a decision yet. Mr. Chairman, I move to grant the appeal on their application 25-23.
All right, do I have a second? Or do I second it? Then I second it.
All right, Chairman seconds it.
Yep. Adrian?
Nay.
Nay? Okay. Herb?
Nay.
George?
Nay.
Okay. So gets that part finished.
So that's 3 to
Is it?
2
Sustaining-
against my application, so therefore the building inspector's decision stands.
Correct.
Very
Okay.
good.
So that's it.
Motion, we take this business section and end the meeting.
All right, those in favor of closing the meeting, say aye.
All right.
Painful.